It happens year after year after year. Delhi AQI hits the very poor category. Delhiites are gasping for clean air. SC pushes for long-term solutions, directs Punjab and Haryana to comply with CAQM. Everlasting solution is the only option.
Alright, since the past 1 month, Delhi and the National Capital Region are once again choking under dangerously polluted air. The Air Quality Index, which is the AQI, used to gauge how clean or toxic the air is, has shot up to levels that threaten public health. While this is an almost yearly ritual, the Supreme Court has now stepped in with pointed questions. Are the AQI monitoring stations reliable? Is the data being reported even accurate? And crucially, can we trust the system that triggers pollution control measures when data itself may be flawed? This is not just a matter of environmental concern, it's a constitutional issue too. A PIL has been filed alleging that the very right to breathe clean air under Article 21 of the Indian Constitution is being compromised because of systemic failures in monitoring and governance. The public interest litigation is being brought forward by Luke Coutinho, a wellness coach who argues that the air pollution crisis is a national health emergency. Some of the main demands and arguments in the PIL are as following. First, Coutinho's petition frames air pollution as a constitutional threat. Clean air is not just a nice to have, it's fundamental to life and dignity. Second, several existing frameworks like the Air Prevention and Control of Pollution Act, the Environment Protection Act, and the National Clean Air Program are not being effectively enforced. Third is the problem of underused funds. According to the petition, large amounts of money meant for clean air programs remain unspent or used in suboptimal ways. For example, the funds have been spent focusing narrowly on cosmetic fixes like anti-smog guns and sprinklers instead of addressing root causes such as industrial emissions, vehicular exhaust, and crop residue burning. Fourth is lack of monitoring and transparency. The plea demands better, more transparent, and more widespread monitoring of air quality not just in major cities but across rural and peri-urban areas. Fifth point is a demand of an independent committee. Coutinho proposes constitution of an independent expert committee, stronger monitoring networks, source apportionment studies to understand exactly where the pollution is coming from, and binding timelines for pollution control. But the Supreme Court has turned down this fresh petition from health coach Luke Coutinho. Instead, the court has allowed him to withdraw his plea and file an intervention in a pending case filed by environmentalist MC Mehta on pollution. The Supreme Court, before allowing this PIL withdrawal, had made important and strict remarks on the deteriorating AQI in the national capital and has raised some very serious red flags. The court has told that out of 37 air quality monitoring stations in Delhi, only 9 were functioning on Diwali. This is deeply problematic because the Graded Response Action Plan, which is a set of emergency measures that the government imposes when pollution crosses a certain threshold, depends on real-time accurate AQI data. If the monitoring network is broken, how does one know when to trigger GRAP? A counsel assisting the court, or the amicus curiae, made this exact point, and I quote, "If the stations are not functioning, we won't know when to implement GRAP." Beyond just not working on Diwali, there were reports that hundreds of hours of PM 2.5 data are missing from many stations for the month of October. When the hours are at peak, data goes black. The missing data raises serious questions about data integrity and whether the recorded AQI levels are giving an accurate picture of how bad the pollution really is. Third point raised by the Supreme Court was possible manipulation of data as water sprinkling near monitoring stations is being done. The court asked the Delhi government to explain what kind of equipment is being used for AQI monitoring and how efficient or accurate the equipment really is. This demand comes against reports or allegations that water sprinklers are being used near some AQI monitoring stations, potentially to artificially suppress readings. This could be a deliberate tampering of data, which would seriously undermine the entire pollution response architecture. The next directive came from accountability of states including Punjab and Haryana. The Supreme Court directed Punjab and Haryana to submit detailed data on what they are doing to curb stubble burning. During hearings, the court emphasized that there must be concrete evidence of policy action, not just political statements. The bench explicitly told the states on the strict implementation of Commission of Air Quality Management, recent activity and directives is needed. As a conclusion, the court has reiterated that pollution control measures should not wait for the AQI to become severe. There is an expectation of preemptive action. In one of its older orders, the Supreme Court had said that it was wrong for authorities to wait for AQI to cross thresholds before triggering GRAP. They should act in anticipation. Let's look at what the Supreme Court decided for its next steps. The court has also asked for detailed reports from CAQM and the Central Pollution Control Board on their proactive strategies, especially during high-risk pollution periods. Next, the Supreme Court has asked the Delhi government to file an affidavit within 2 days explaining the nature of the AQI monitoring equipment used and how accurate, efficient they really are. Third order was on the stubble burning data. Punjab and Haryana must provide detailed data on stubble burning and what they are doing to reduce it, especially in light of Supreme Court's prior directives. The Supreme Court expects that if there are lapses like non-functional stations or tampering, the authorities must fix them, and ideally in a way that ensures more reliable and transparent data going forward. This case, though focused on Delhi NCR, could have national ramifications. If Supreme Court pushes for better AQI infrastructure and more accountability here, other polluted cities could demand similar oversight. Moreover, the National Clean Air Program could be reformed or strengthened based on the Supreme Court's findings, particularly for monitoring and data transparency. Next, the PIL and the Supreme Court's involvement might encourage more citizen-led litigation on environmental rights in India. It is also possible that the court's insistence on data quality, preemptive action, and independent expert evaluation could push air quality governance to be more scientific and less reactive. The Supreme Court raising these issues is a big deal at its core. The court is questioning whether the very system meant to warn people about pollution is working as it should be. If the AQI monitoring network is faulty, the data is missing, or there's manipulation, then the legal machinery meant to save lives like GRAP could be failing at its most basic level. The PIL by Luke Coutinho gives this judicial scrutiny a sharper frame. Access to clean air is a fundamental right, not a policy concession. The Supreme Court's orders reflect not just concern but a demand for accountability, transparency, and scientific rigor. What happens next will be crucial. Will authorities fix the gaps? Can they rebuild trust in the AQI monitoring system? And will this intervention lead to stronger systemic reforms or just temporary fixes?
It happens year after year after year. Delhi AQI hits the very poor category. Delhiites are gasping for clean air. SC pushes for long-term solutions, directs Punjab and Haryana to comply with CAQM. Everlasting solution is the only option.